From TeachIllinois.com, this is The Teacher's Classroom, the podcast that explores current issues and topics in education and how they relate to teaching and students. Here is your host, Matt Weld.
Hey, welcome to episode number 11 of The Teacher's Classroom. Today, we are going to be talking about LGBTQIA legal issues in schools with Attorney Chad Watkins. If this is your first time listening, thanks for joining us, and be sure to subscribe so you'll be notified of any new episodes. The Teacher's Classroom is produced semi-monthly and is supported by the Area 5 Regional Offices of Education here in Illinois. Information about the podcast and any associated documents can be found at www.teachillinois.com, an online professional development platform. Our guest today is Chad Watkins. He is an attorney based in Edwardsville from Tuith-Keeney Law Firm. You can find them at www.tuithkeeney.com. His practice is primarily in the area of school law, and he represents school districts throughout Illinois in matters related to student rights, special education, and disciplinary matters. During law school, Chad tutored and taught classes at University City High School and Northwest Academy of Law. Before law school, Chad taught high school special education and coached girls varsity basketball in Washington, D.C., which is why we love having Chad on the show, because he knows what it's like to be a teacher and has that additional layer of understanding the law on top of it. So welcome back, Chad.
Hey, thanks so much for having me, Matt. It's great to be here again.
Well, last time I know we were talking about student privacy and all that kind of thing. Mm-hmm. And so I think this is another big issue that it is coming to the forefront of people's minds. I know it's been on administrators' minds, but I know that classroom teachers as well, you know, they have transgender or, you know, lesbian, gay students in their classroom, and they want to know how to best support and be respectful to their students.
Absolutely.
Right? Yep. Yeah. So let's just start off with the beginnings.
Sure.
When we talk about LGBTQIA, what exactly are we talking about?
I think this is a great place to start, because before we get into the law and what districts need to know about what to do, they need to know what we're talking about in the first place. So it's important to understand the meanings of these terms that make up LGBTQIA and the distinct concepts in which each of them fall. There might be different definitions based on where you get information about these terms. So I would encourage, in addition to what I'm going to say, that everyone listening to this does their own research and make sure that they understand this for their students. So really quickly, LGBTQIA stands for lesbian, gay, bisexual, transgender, queer, intersex, and asexual. And within those terms, there's 4 different concepts that I want to go through and make sure that everyone understands. The first one is sex or biological sex. Now, this is a medically constructed term that applies usually to the assigned sex at birth as male, female, or other category based on the appearance of the genitalia. The other category, the other umbrella term for assigned sexes that don't necessarily fall into male or female is intersex. And that applies to many different characteristics on the spectrum between male, female, or even having characteristics of both. The next big concept is gender identity. And this is a sense of oneself as a woman, as a man, as neither of those, or some other identity that may or may not correspond with the assigned sex at birth. Two big terms that we should understand here within gender identity. The first is transgender. And this is an umbrella term which includes people whose gender identity differs from their assigned sex at birth. The other term is cisgender. And this refers to people whose gender identity generally fits society's expectations of their assigned sex at birth. The next and related concept to gender identity is gender expression. And this is how one expresses themselves, usually in regards to dress and behavior. These are commonly referred to as masculine, feminine, and androgynous. And it's important to understand that each of these concepts are not necessarily a binary. There's a huge spectrum of where people can land. And the last concept, which is a distinct one from the other three that we've raised, is sexual orientation. And this is a romantic attraction or non-attraction to other people. Gay, which would be attraction towards people of the same gender. Lesbian, a woman whose primary attraction is toward people of the same gender. Bisexual, primary attraction is toward the same and other genders. Asexual, not feeling an attraction towards others. And pansexual, which would be a romantic attraction towards people of all genders and sexes.
So that's interesting that there's, I think in society in general, we are understanding that human expression is on a spectrum.
Exactly.
Even with autism, it's a spectrum. Mm-hmm. And so I think it's interesting that we're finally understanding and vocalizing the fact that gender expression is also on a spectrum.
Exactly. And I think it speaks to the progress that we've made, that we are respecting and listening to the voices of people whose experience differs from what maybe the majority experiences. And as I'll explain throughout this podcast, the law is starting to respect those differences a little bit more as well.
All right, so let's jump into it. So
Sure.
Now that we understand these 4 different concepts that you went over, mm-hmm. How should schools address these issues?
Well, I would start with a couple overarching principles that when an administrator or when a teacher is faced with the situation where they need to know how to appropriately respect the dignity of all their students, that they need to keep in mind. The first one is that all of your schools should have non-discrimination policies that must be followed. And know that under no circumstances can students be discriminated against based on their sex, gender identity, gender expression, or sexual orientation.
And then that would be part of the board policies.
Yes,
is that correct?
Yes. And that's included in, I would assume, every district's board policies.
Gotcha. Okay.
The next big concept, and this is something that districts are already doing, is that every single student that comes into your school should be treated with the dignity and respect of them as a person. Respect their individuality, respect their experiences that they're bringing to the school. I mean, those things are important, and I'm sure those things are already being done to your students, which is another thing to keep in mind when facing these types of situations. The third overarching principle is, and I can't say this enough, it is important to establish relationships with the parents, family, and the students. When you can have a personal conversation with them, that will usually address 99.9% of these situations. And if there's an amicable solution, it works for the individual student as well as the rest of the student body and community as a whole, that's usually the ideal way to handle these.
Well, I think that works with discipline and
exactly. This is
pretty much everything,
this is
right?
No different than any other student situations that you should face. And I think if you think of it as just, student oriented, just like anything else, you'll be just fine.
Yeah, I think a lot of people who are who identify as a male, and mm-hmm. so they fit the societal norms, that this kind of thing scares them, and they don't quite know how to handle it. Just something new. And so I think if you just realize that people are people.
Exactly.
Right. And everybody values a good relationship and good communication, no matter who they are.
I think that's a great point. I think when you don't necessarily know what another person is dealing with, or their identity is something that's unfamiliar to you, you're not going to understand the nuances that they're faced with. And I think any opportunity for people who are leading school districts to talk with people in different communities is going to pay a lot of dividends in the long run for their student body.
Yeah. I've been reading a lot about just awareness in general. Mm-hmm. Political awareness, social awareness, that kind of thing. And I think one of the best questions I came across, and probably one of the hardest things for people to do, and yet it's really easy, is when you disagree with someone or don't understand their position, you simply say, "Tell me more."
I think that's great. And schools are going to be a place where everyone in the community is going to come through the doors. And it needs to be a welcoming place. It needs to be a respectful place. It needs to be a tolerant place. And that doesn't necessarily happen overnight. It may take work. But like I said, I think it'll pay dividends in the long run for the school leaders.
Right. All right. So you were talking about establishing relationships, putting it in policies. Mm-hmm. What else?
Those are the big ones. And I think the next thing is just have an understanding of where the law stands right now.
All right. So how about recent case law that supports all this?
Okay. So we have, I'm going to say 3 pretty recent cases within the Seventh Circuit. Now, real quick explanation of the judicial circuit courts. There's about, I think 15. Don't quote me on that. I may be wrong, but about 15 circuit courts across the country. And Illinois, Wisconsin, and Indiana are part of the Seventh Circuit. And the law that is decided there is usually a good guidepost for how school districts and any other entity that lives in those states for how they should follow the law. Of course, the Supreme Court sets the law of the land, and this issue has been getting a lot of litigation throughout the country. So I think eventually a case related to these issues will get to the Supreme Court and provide more guidance to the districts on how to handle this. But go ahead. I'm sorry, Matt.
I think, can we just back up and just, this is probably law 101 mm-hmm. or maybe even 100. But so a school district, I just want to know kind of like the hierarchy of the court. So a school district and a family, say a family sues a school district, mm-hmm. and that goes to, is that a county court? And then can you tell how it then gets to the Seventh Circuit?
It gets even more complicated because you could either bring the suit in state court or federal court. But a lot of times claims based on sex discrimination that I'm going to get into are brought in federal court because they are based on federal laws. So if they chose to go the federal route, the suit would be brought in the district court, and then the district court decision could be appealed to the Circuit Court of Appeals, which for Illinois, Wisconsin, and Indiana is the Seventh Circuit. And then if that decision were appealed, then it would go to the Supreme Court.
So when you say these decisions are from the Seventh Circuit, it's basically like second tier.
Yeah, the tier below the Supreme Court. But the Supreme Court hears a lot fewer cases than the appellate courts, so it's still a pretty impactful decision.
Okay. All right. Sorry. Go ahead.
No problem. I just, got to make sure it gets a little complicated. I want to make sure that's a basis for understanding these next couple cases that I'm going to get into. Another thing to point out is that these 3 cases were not decided at the end of a long trial of hearing all kinds of evidence. They were done on a pretty early stage in the proceedings. So these, while what they say should be taken to heart, understand that they weren't comprehensive looking at all the evidence of the cases. They were done at an early stage, like the summary judgment stage, prior to trial would be the best way of explaining it.
Okay. And so the timeline for these, like between the time somebody first files suit until these come out,
it could be quite a long time.
Okay. So I was just curious as to, sometimes education moves quickly and there are other parts that move really slowly. And so I was just wondering.
I will say the law moves slowly.
Okay. All right.
Sure. So let's get into these cases here. The first one I'm going to point to is Hively v. Ivy Tech. And in this case, a part-time adjunct professor who identified as a lesbian sued the community college where she was employed, claiming that she was denied promotions based on her sexual orientation. She brought her claims alleging sexual harassment based on Title VII of the Civil Rights Act of 1964. Now, what the court was faced was, and again, this was an early stage in the case, was determining whether discrimination based on sexual orientation could be considered sex discrimination and a potential violation of Title VII of the Civil Rights Act. Now, why that is important is because if it was sex discrimination, there is a heightened level of scrutiny. Whereas in the past, discrimination based on sexual orientation was reviewed under rational basis, to where the district or the other public entity could have their policy that maybe treated people of a different sexual orientation differently. All they had to show was that there was a rational basis for their decision, the lowest threshold for justifying it. But by finding that sexual orientation discrimination was actually sex discrimination, the districts and other public entities are held to a higher level of scrutiny. And in this case, they did. They found that sexual orientation discrimination was sex discrimination. And for a policy like that to be in place, the school must demonstrate a justification that is exceedingly persuasive instead of the lower rational basis standard. So what this means is that if any sort of district wanted to have a policy that treated people differently based on sexual orientation, the reason for that policy must be exceedingly persuasive. In other words, impossible, almost impossible.
Right.
Mm-hmm.
Okay.
Yeah.
Yeah, I can't think of one, but okay.
Yeah, exactly. The next case that I'm pointing to is more school specific, and this is Whitaker by Whitaker v. Kenosha Unified School District. And in this case, we're talking about a 17-year-old transgender student named Ash Whitaker. Top 5% of the class, very involved in tennis, theater, other events, and the district in a lot of ways was very accommodating. They allowed him to wear tuxedos to the prom. They used the student's preferred pronoun, and they referred to him as Ash, which was not his birth name. The issue came regarding the bathrooms, and the district had a policy that Ash could not use the boys' bathroom, which matched his gender identity. And he brought a suit based on Title IX, a sex discrimination claim, and the Equal Protection Clause of the 14th Amendment, again, claiming that this was sex discrimination. Now, in the previous decision, they found that discrimination based on sexual orientation was sex discrimination. In this case, the court found a high likelihood of success based on the claim that discrimination based on gender identity was sex discrimination, which effectively means that the school would have to demonstrate a justification for sex-based classification that is exceedingly persuasive instead of the lower rational basis standard. So what this means is that for the school to exclude Ash from the boys' bathroom, they would have to have an exceedingly persuasive justification. Now, once again, this was at the early stages of the case, and there wasn't a full trial sharing all the evidence. But at the summary judgment stage, they made a determination that the school did not have a persuasive justification to keep the student out of the bathroom. I want to read directly from the opinion because I think this is important to keep in mind. A transgender student's presence in the restroom provides no more of a risk to other students' privacy than the presence of an overly curious student of the same biological sex who decides to sneak glances at his or her classmates performing their bodily functions. for that matter, any other student who uses the bathroom at the same time. Common sense tells us that the communal restroom is a place where individuals act in a discreet manner to protect their privacy, and those who have true privacy concerns are able to utilize the stall. So this opinion suggests fairly strongly that if you treat a student, a transgender student, differently, it's going to be hard to justify that. It's going to be hard to overcome the claim of sex discrimination. And as I found, that applied to the bathrooms.
All right. And so in summary, I've been jotting down some notes here. It sounds like the first case, Hively versus Ivy Tech, was sexual orientation found as sexual discrimination. That's right. And in the second one, it was gender identity as sexual discrimination.
That's correct.
Okay.
That's correct.
All right. So those are
two recent cases.
Tying back then to the definitions we talked about at the beginning, these sound like somewhat like, can we use the term landmark cases?
I would say so. I mean, both of them have been much talked about, and other circuits have looked to these cases as a basis for their later decisions. Some circuits have followed it, some circuits have not. And it may get to the Supreme Court soon, but for right now in the Seventh Circuit, these are landmark cases. These are the guidepost that districts should keep in mind when they're making their decisions.
Okay. All right. And so
one more case I'd like to quickly bring up. This was a Students and Parents for Privacy, and they sued the United States Department of Education and a school district in Illinois, and they sued on behalf of girl students who were sharing a bathroom with a transgender girl per the school's policy. And they claimed that their right to privacy was infringed based on this arrangement. And basically in this case, the court did not accept their argument. This is a district court, not the appellate court. Did not accept their argument and pointed to the Whitaker case as saying that the district would have to show an exceedingly persuasive justification to discriminate against the student based on the gender identity. And the school district and they found that the school district's decision to let the student use the bathroom did not infringe upon the rights of the other students who were using the bathroom.
And then the other students' personal feelings of transgression or violation or whatever did not amount to the what was it, the major reason that the school.
And I'd like to read from this opinion as well. This case did not involve the forced or extreme invasions of privacy that the courts addressed in other cases. Further, the restrooms at issue here have privacy stalls that can be used by students seeking an additional layer of privacy, and single-use facilities are also available upon request. Given these protections, there is no meaningful risk that a student's unclothed body need be seen by any other person. So, in conjunction, what these cases are saying is that if you're going to treat a student or an employee differently based on their sexual orientation or based on their gender identity, you could be facing a discrimination claim.
Mm-hmm. Okay. All right. And so taking those cases into account, how now should districts address bathroom usage?
Well, again, I would always start with the overarching principles. Don't discriminate. Treat your students the same. Every single student who comes into your school should be treated with dignity and respect, and establish relationships with your parents, family, and school community. If you have those things in place, you can work with the individual student and come up with an arrangement that best addresses their concerns. If you experience pushback from other students from your arrangement, again, I think you need to be thinking about your whole district. You need to be thinking about the community. But you need to be aware of these cases, that if you do not allow a student to use the bathroom of their gender identity, then you are facing a risk should the student sue based on sex discrimination.
So, putting on my principal hat here. So, a student, let's just say I have a student come in over the summer. So I don't know, I have no history with this student, right? Comes in over the summer. They make a request for alternate settings, I guess. And so the best thing to do would be to reach out to the family.
Yeah.
I guess, and figure out what they're comfortable with. Or
I think an important factor in thinking about the family's concerns and the individual student's concern is the age of the student. Again, like you said earlier, any other issue that faces your school, you're probably going to address it differently based on the student's age. If this is a younger student who raises concerns on anything, you're probably going to talk to the parents and see where they're coming from and talk about the issue and figure it out. But I think the older the student is, the more autonomous they can be in making their decisions, just like any other issue that the student would be bringing to the school.
That's true. Yeah. I come from a middle school background, so I'm always
right in the middle. Yeah.
got the younger kids in mind, I guess.
Yeah.
All right. Okay. So what about locker rooms?
I think locker rooms and bathrooms are treated the same way. Again, go back to your overarching principles, but recognize what the recent decisions by the court have been. And know where the Seventh Circuit stands, that if you are treating students differently based on their sexual orientation or their gender identity, then it's possible, if they sue and take it to the court, that you could lose a discrimination claim.
So theoretically then, providing student access to the nurse's bathroom or something like that could be treating them differently than other students.
When would they be using the nurses? Well,
so if they had access to the nurses, so it would be more like a private bathroom.
Yeah. Well, if you work, each student's going to be different, and their choice of what bathroom they may want to use or what locker room they may want to use could vary no matter who the student is. I think another thing to keep in mind is, how would you treat a differently situated student per the same request? Like if the student has, whoever the student is, if he or she had issues changing in the PE locker room, how would you address their request for an accommodation? And I think it's important to address those requests in the same way.
So even if it weren't a gender issue, but a privacy issue, just someone who was super shy.
I think so. I think that's a good rule of thumb, is that you're not discriminating. You're treating all students in the same way. So if a student's making that request for the private bathroom, you look into the situation and you come up with a solution that works for all parties.
Okay. How about overnight trips?
I think overnight trips should be treated the same way. I don't think there's much of a distinction between bathroom usage, PE locker rooms, overnight trips. I think your same overarching principles are in place, and you keep in mind what the recent case law is from the Seventh Circuit.
All right. So if you're on my daughter was in band. So let's just say they're on a band trip, and a transgender female wants to room with other girls. Does the school have to allow her to do that, or?
Well, I would go back to working with the family, working with the student to find a solution that works for, in this case, her.
You'd probably also be working with the other families as well.
Of course you would. You would be working with the families. You think about the school community, but you keep in mind that where the law stands now in the state of Illinois is that if you're treating that student differently based on their gender identity, you are facing a sex discrimination claim.
Okay.
Like I said, let me add this one more point because I keep going to the Seventh Circuit. We may have a Supreme Court opinion in the next year or two, which provides a more definitive answer on some of these questions. But the Seventh Circuit, these recent cases that I went over, that is a guidepost that you should be keeping in mind when handling issues related to sexual orientation and gender identity.
Okay. All right. So what about student records? I know we've talked on this show about student records before.
Yeah. So in looking at recent changes to Illinois laws, I mean, there is a process in which students can have their birth certificate legally changed. And I would absolutely recommend to all districts to follow what the student's birth certificate says. But if the student chooses to go by a different name or a different gender pronoun or wants some aspect of their demographic data changed, the ISB system allows you to do that. And I think, in deciding what to use, it goes back to your overarching principles, and you keep in mind where the law is now for your case. And if there's a difference between what the parent says and what the student says, the key consideration is the student's age. And like other issues that the students would bring to school, sometimes you really need to check in with the parents to see, hey, is this really what's going on? Just like you would for anything else.
So if you're talking a high school senior and their high school diploma, the name that they request to put on there so that would be more up to the student?
I think the high school senior would have a lot more autonomy over their pronouns, their preferred name for all aspects of their education than a younger student who you would need more parent input. But again, this is a developing area of the law that could be decided soon. I know the state of Delaware recently issued some proposed regulations that would change that process for changing the demographic data, and we'll see where Illinois lands soon.
So right now, it's up to the school and the student to come to an agreement about what name gets put on a diploma,
and again,
for example.
And you're right. And the district should keep in mind, based on these cases, if you are treating a student differently based on their gender identity or their sexual orientation, that possible sex discrimination suit is there. So
okay. All right. So any other topics of concern in this area?
Just a couple more quick things. The first one that I want to bring up is a bill that was passed by the Illinois Senate regarding teaching LGBT history in schools.
Yeah, I saw that.
Yeah, based on the latest report, the House has not taken action on it yet, but this may be something that will be coming down the pike within possibly in the next session.
And so that would require schools to include LGBT history.
That's right.
In their curriculum.
That's correct.
Okay.
Another thing I'd like to bring up is possible liability for student-on-student harassment. Say that you have a student who is being bullied based on their sexual orientation or based on their gender identity, gender expression. Know that, and again, I've said this a few times, a sex discrimination suit is possible. And under Title IX, if the student was harassed based on their gender status, the school had actual knowledge of the harassment was severe and pervasive, and the officials were deliberately indifferent to the harassment, then there could be liability after all that. So the key there is make sure that districts are taking proactive steps if students are being bullied based on their gender identity or sexual orientation.
Fair enough.
Yeah.
Okay. All right. Yeah, I think this has been a pretty comprehensive discussion. Is there any other final words of wisdom you have for us, Chad?
I know I sound like a broken record, but respect the dignity of all your students, work with families, and you will be able to resolve all issues facing your school. That's a pretty broad statement.
That is. And I'm going to add an even broader one. Just keep communication open.
Absolutely.
between the parents in the school, between the classroom teachers and the administration, just everything.
For sure.
Yeah. All right. Well, let's leave it at that.
Okay.
All right. So, Chad, thank you so much for your knowledge and expertise.
Thank you for having me, Matt.
It's great to have you on the show again. And we look forward to having you be our legal expert again.
Fantastic. Looking forward to the next opportunity to be here.
Perfect. All right. And thanks, everyone, for listening to the Teacher's Classroom, which is part of the Illinois Area 5 Professional Development and Innovation Initiative. I'm your host, Matt Weld. Please subscribe to the show and share today's episode with your colleagues. You can follow Teach Illinois on Twitter at TeachILPD, and I can be found at Matthew Weld. You can find and subscribe to the Teacher's Classroom on iTunes, SoundCloud, Stitcher, as well as your favorite podcast apps. So, in closing, again, thanks to Chad. Have a fantastic rest of your day, and I'll see you next time right here on the Teacher's Classroom.